Welcome to the Grow Your Business and Grow Your Wealth podcast with Gary Heldt. Gary is an expert in helping business owners put together a plan that will provide a better future for their businesses, themselves, and their families. On the podcast, Gary interviews other professionals who share his vision, and together they share secrets and strategies any business owner can use to build a better financial foundation for your business and your life.
Welcome back to the podcast. Today, our guest is Steiner with Steiner Law Group, LLC. He is the managing member. Welcome, Eric.
Hi, thanks for having me. It's great to be here.
So tell us, why is it that you decided to focus a career in law?
So law is one of those careers that makes a dramatic impact on people's lives. And really, I started to realize the impact that I can make, the positive impact that I can make in people's lives when I went out on my own in 2014. Before that, I was working for various law firms. I represented banks and I represented institutional clients, insurance companies, and there's really no face to a client like that. But when I sit down with a client and talk about their wages are being garnished, or their house is going to be foreclosed, or their business has just been crushed by COVID, I've immediately realized the positive impact that I can have in their life. And it's that personal connection and that ability to use law as a tool to really help people that drives me today. And it's why I'm passionate about law. I love writing. I love the research, and the fighting I don't like so much, but if I have to fight, I have to fight. And ultimately, I know that I'm very careful about what battles I choose, because I want to only fight the battles that I have a good chance of winning.
Right. So you've gone out on your own, and now you're specializing in bankruptcy. What in your past experience has really given you the tools to do that and really kind of pushed you to doing that? You know, I know you say that you like helping people, but what kind of got you going there?
That's a great question. So I started law school in 2004, and I signed up for a bankruptcy class, and my professor told me, well, if you haven't taken this other course of mine, you should take that other course. So I actually transferred out of the bankruptcy course, took the other course. I never ended up taking bankruptcy. I never thought I'd be practicing bankruptcy, believe it or not. I did commercial collections for a large bank. So what that looks like is the bank makes a loan to a business, and I am the lawyer that's dragging the owners of business to court, asking them about all their assets to see what I can take. You know, I was sort of on the dark side at that point in my career. And then, you know, when I came home at night, I looked at the work as just a job. As I mentioned before, I was just representing this faceless bank. There was no personal connection. I didn't really have any passion. But when I went out on my own and I started to see the impact I could have, that completely changed. So I went out on my own in about 2014. I kind of took whatever came in the door, because I had a lot of different experience in different areas of the law. And I found that with bankruptcy, I really enjoyed the work, and I was able to really help people relatively quickly. I mean, when someone files a bankruptcy with the court, all collections stop automatically. It's called the automatic stay. And that can happen as soon as a week after I meet with that client. If we can get the case done in a week, then we can get that protection right away. We can stop a garnishment, and we can stop the collections and everything like that. We can get their bank accounts unfrozen. We can stop a foreclosure sale. We can help them keep their house. And, you know, seeing that impact that it has, and also bankruptcy is one of those areas that is constantly challenging. There's always new things to learn. There's always new nuances that I learn from my colleagues, and just when I'm faced with an issue that I haven't been faced before. And bankruptcy is one of those areas that there's just so much to learn. So I'm constantly challenging myself. I'm constantly learning new ways and how I can be more effective my clients. I also, something that's very important to me is making sure that I communicate very effectively with my clients. That can be very difficult. I may have a client that understands the difference between a whole life insurance policy and a term life insurance policy, but I'll tell you, most of my clients don't understand it, and it's my job to explain the difference and to explain why we need to see that and how all these pieces fit together. So I really found myself in that position to challenge myself and at the same time help people.
So it sounds like with bankruptcy that at least to get started can be very quick, and you can give relief to your clients pretty quick with this. What are some of the mistakes that the clients make when they come in and they talk to you about wanting to go the route of bankruptcy?
So many people view bankruptcy as a last resort, and often to their detriment, unfortunately. There's some examples that I see very frequently. In fact, yesterday I was on a virtual court hearing, and before my client came to me, she went to a debt consolidation company. She spent $6,000 on this debt consolidation company that didn't do what they promised to do for her, and she had lawsuits against her, despite the fact that this company promised to help her deal with the creditors. She paid me less than that $6,000, and we filed a bankruptcy. We got her into a payment plan of $105, $110 a month for a little over 3 years, and that's it. And then she has about $25,000 of debt. The rest of it's going to go away at the end of this really easy payment plan. So that's something I see, unfortunately, very often. People try to go to a credit repair or a debt consolidation, and those outfits, they tend to be less reputable than a court overseen process,
Right.
like that bankruptcy is. The second thing is that, I can't tell you how many times I've seen that people cash out their retirement before they decide to file bankruptcy. So they're faced with a lawsuit for a credit card. Let's say it's a $15,000 lawsuit. They'll cash out their retirement and they'll use that money to pay off a credit card. That has so many negative impacts. First of all, in bankruptcy, retirement accounts are generally completely protected. Creditors cannot touch them.
Right.
And the second thing is they're going to owe a massive tax penalty by taking an early withdrawal from that account. And they're using it to pay off credit card debt, which in bankruptcy falls all the way at the bottom of the priority scale, which doesn't have to get paid anything in bankruptcy. So people think of bankruptcy as this last resort, as giving up, as shirking your responsibilities, but nothing can be further from the truth when it comes to that, because all these other things that they're trying to do before they come to me that they think are better options are actually hurting them, both in the short term and certainly in the long run.
So there's different types of bankruptcy. Can you kind of tell us what they are?
Absolutely. So there's three main chapters that we see. Chapter 7. Chapter 7 is called the liquidation chapter. It's a quick process generally, depending on the complexity of the case, but if it's a routine case, it's about, let's say, 6 to 9 months. With COVID, so things are taking a little longer. And in a personal Chapter 7, so if it's a consumer, it's a family, it's an individual that needs to file Chapter 7, they can eliminate credit card debts, medical bills, other what we call unsecured debt, sometimes even tax debt, and they don't have to make any payments. But there are many limitations to doing a Chapter 7. Chapter 7 is called the liquidation chapter, so we have to make sure that we can protect all of our clients' property in Chapter 7. Because what happens is the court appoints a trustee. The trustee's job, Chapter 7 trustee, is to go through the paperwork and see, what can I get? Can I take their car? Can I take their house? Can I take their bank accounts? And my job is to advise my clients on, well, this is how we protect this asset. This is how we protect this asset. This is why a trustee won't be interested in this asset. This is how we can strategize to position yourself so you're in a better position for a trustee to be less interested in this asset. So the classic example of a Chapter 7, somebody is not a high earner. Let's say they're a family. They have 2 kids, and between the husband and wife, they earn, let's say, $100,000 a year. They have, let's say, even $75,000 of credit card debt. Ooh. And they have no equity in their house. They have 2 cars with loans on them, not much in their bank account. And let's say they have a 401k. All of that could be protected in the Chapter 7. That would be a perfect example of a Chapter 7. Chapter 13, however, is where the client does make payments over the course of 3 to 5 years. And there's many advantages to Chapter 13 that are not available in Chapter 7. Chapter 13 has more ability to restructure debt. So what that means is, let's take a car loan. They can lower the principal, they can lower the interest rate, and they can extend the term. What that translates into is it could be a much lower monthly payment. Mm-hmm. Somebody has no equity in their house, and they have after their mortgage, and they have all these other liens, tax lien, judgment liens, HOA liens. We can get rid of all of those. I did a case where they had 10 different liens from their HOA because my client didn't pay the HOA for their homeowners association dues, and the homeowners association can place liens, and they literally placed 7 statutory liens, and they filed 3 lawsuits. So they had 10. They actually scheduled a sheriff's sale. They wanted to sell my client's house. I got rid of all 10 liens, stopped the sheriff's sale, and I think my client maybe paid, I think it was like $250 a month for I think it was 5 years or something like that. So that's where Chapter 13 is very powerful. It has different ability to restructure debt. Also, if a client has valuable assets that can't be protected in the 7, 13 could be a good option. The final option is Chapter 11. Chapter 11 is used for typically if Chapter 13 has certain debt limits. So you have to have below a certain amount of debt in order to file Chapter 13. If you're above those debt limits, you can look into a Chapter 11. It's the most complex chapter. There is no trustee appointed. The debtor is called a debtor of possession. They manage their own financial affairs. They have to have a separate bank account. United States trustee is directly involved. These are much more complex and therefore expensive cases. They're also used by businesses who want to restructure debt. They can file under Chapter 11.
Right. So what are some of the things that cannot be discharged under bankruptcy?
So that's a great question. The most common, the number one thing that can't be discharged are child support and alimony. Can't get rid of that. You can't get rid of certain kinds of taxes. There's a 3-part test to determine whether the taxes can be eliminated in bankruptcy. You can't get rid of, unless certain conditions are met, you generally cannot get rid of a lien. So, for example, if a client has a car loan, there's always 2 components to what we call secured debt. There's a note and there's an instrument that secures the property as collateral. The note says that if the client gets sued, then if the client gets in default, they don't pay their car loan, the car lender can then sue them personally, try to garnish their wages, bank accounts, all that stuff. That's called personal liability. Then there's the security instrument, which allows the lender to repossess the car. Same thing for a house. So there's a note, and it's called a deed of trust. Note means we can sue the homeowners personally. Deed of trust gives the lender permission to foreclose. So in bankruptcy, let's say it's Chapter 7 on a car, you'll get rid of the personal liability, but the lien will still survive. So practically what that usually means is, as long as the client keeps paying on the car, they'll be completely fine, no issues. If they stop paying on the car after bankruptcy, the lender can just repossess. They won't be able to sue them personally and try to get their wages. So those liens will survive bankruptcy. Something we don't see very often, but we see it from time to time, is if a debt was incurred through fraud. So for example, if someone lied on a loan application and said they make much more money, or have less set than they did, that could be a basis to object to what's called a discharge. Discharge is a court order that eliminates certain kinds of debts, and there are bases for particular kinds of claims or lenders to object to the discharge. So fraud, anything like that. If the certain kinds of injuries, if somebody was criminally charged, they have criminal fines, things like that, those may not be discharged. And often easy pass fines, toll booth violations, parking tickets, those are much more tricky to get rid of.
So one of the things I key on, obviously, because we do a lot of tax work with clients and stuff, and you brought up earlier about your client that worked with a debt consolidation company, and they had her cash in her 401k, and then then she has the taxes now that she's got to worry about. So I know that that's something that we constantly run into, where people want to, oh, here, let me just take out of my 401k, pay this off, but then they don't realize, well, now you got to pay tax. If you're under 59 and a half, you got to pay the penalty on it. So, that always seems to kind of come back and bite them in the butt. And then they're in this vicious circle. And based on what you're saying is typically the taxes aren't discharged in bankruptcy. So in that situation, they're much better off just keeping that credit card debt going through the bankruptcy instead of, doing the 401k.
Absolutely. Oh, sorry.
So besides the 401k, what are other assets that typically in bankruptcy, and I know there's different rules for everything, but typically are items that will not be forced to be sold or liquidated?
That's a great question. Any asset like a car that has a loan, for purposes of the bankruptcy, the bankruptcy trustee would only be interested in any equity in that asset.
Okay.
So most of the time, cars are underwater. If there's a little bit of equity, there are about $11,000 of exemptions we can use that pretty much apply to most property. Just blanket. That's for one filer. Two filers, you get 22,000 doubled. There's also various other exemptions we can use to protect different kinds of property. So most often, we were able to protect all the property. Sometimes we can't. In fact, another very important exemption, which is actually a very nuanced thing a lot of people don't understand, is when a couple buys a house together, it's often titled in a very specific kind of way called tenancy by the entirety. That protects any equity in the house against individual creditors or either spouse. So let's say husband has $100,000 of debt in his name only. If the husband and the wife has nothing, if they own the house, they can have no lien on the house. They own it as tenancy by the entirety. And I've done this before. We can file a Chapter 7 for the one spouse and get rid of all that debt.
Right.
Protect the house. That's a massive, massive protection. I just had a phone call with a client last week and I've seen this happen, unfortunately, several times. The house was tenancy by the entirety, so it's completely protected from individual creditors. They went to a lawyer in 2000 and actually decided to transfer the house into two trusts that they had created. The wife had created a trust, the husband had created a trust. They transferred the house 50-50 into the trust completely. And this was something I actually had to consult with several colleagues with. Every time I'm faced with a trust issue, I'm certainly not an estates and trust expert, so I want to make sure I understand that. And the consensus that I reached was they completely breached, they got rid of that special protection there. Yeah. By transferring to these useless trusts, they were revocable trusts, which means they don't offer protection from creditors. So maybe there were some tax benefits. Again, I'm not an estate and trust lawyer, but I don't see any benefits. Right.
Right. So that's a great example of why somebody needs to use a professional like you when trying to go through this. what are some of the fears that your clients have coming in the door to talk to you, that, again, not using a professional like you, are they not going to be able to alleviate?
I will tell you, one of the most common questions I'm asked. I read online that Chapter 7 is liquidation. I'm going to lose my house. I'm going to lose my cars, or I don't want to do Chapter 13. I only want to do Chapter 7, and or I can do a Chapter 7 myself, And then those are three of the most common questions that I hear, and particularly with the risk of a Chapter 7 of losing property.
Mm-hmm.
For example, with that trust example, if the clients would have filed their own bankruptcy, they most likely would have lost their house, the house that they've been living in their entire lives.
Right.
That is something that requires careful consideration. And in fact, anybody that goes into a bankruptcy has to realize that all your assets are subject to being taken by a trustee. So if somebody wants to take that risk, they're certainly entitled to do that, but it is such a risk if they have, let's say they have, and also there's there can be criminal liability for failure to list assets. You're defrauding your creditors. Everything in bankruptcy is signed under the penalties of perjury, that it's accurate and true. There's a meeting of creditors where the trustee will ask the debtor or clients questions under oath. They're sworn in under oath. This is under the penalties of perjury. And the United States trustee, which essentially oversees bankruptcies, they will prosecute criminal people who are filing for bankruptcy and lying and defrauding their creditors. I mean, this stuff does happen. I have not seen it happen in any one of my cases, knock on wood. But because we're very thorough, we'll take our time with it, and thankfully we've done a lot of these cases, and I know exactly what the trustees are going to ask. Mm-hmm. So I use that to inform how I advise my clients. Also, can I keep my car? Can I keep my house? Most of the time, in a Chapter 7, most of the time, yes. And if you can't, we'll advise you on whether a Chapter 13 can do that.
Right.
I want to file under Chapter 7. I don't want to do a 13. Well, did you realize that actually Chapter 13 has certain advantages? You can change your car monthly payment. You can get rid of this lien. You can pay back your taxes over 5 years. You can do all this other stuff. And in fact, we will try to restructure in Chapter 13 plans where, let's say, that general unsecured stuff, the credit card debt, the medical debt that's low priority, I'll always try to pay them nothing and pay only the debts that have to be paid back. Sometimes we can't do that, but that's how I'll go into it, a 13. I want to do a 7. Oh, but you earn $200,000 a year and you're not married, you don't have any kids, you can't do a 7. You got to do a 13, things like that. Or I really want to do a 13 because I want to restructure my card. Well, unfortunately, based on the budget, you can't afford a 13. You're better off in a 7. Things like that. Right. So another thing to consider is once a Chapter 7 case is filed, it cannot be voluntarily dismissed by the debtor, the person who files the case. That's something you have to be very careful, because once you're in it, a trustee is appointed. All your assets are now part of this bankruptcy estate. The trustee can take stuff from the bankruptcy estate. You've got to be really careful. 13, you can voluntarily dismiss. You have that right.
Right. So you doing the dark side of things in the past and the collection side, I'm sure has really helped you understand this so much. I always look at it. I know when we do taxes and we do help people with college financial planning and things like that, I kind of took everything and worked from the front back type thing, just kind of like you've done with the creditors and stuff, like, or with being the creditor and working your way back. So you do a lot of education, just like we do. and you do it to tax groups and other attorneys and things like that. What are some of the most important things that people should know? And are there places that just the, my clients, our listeners, whoever, can come hear you talk about bankruptcy and stuff like that? Is there a forum, or do you have a place on your website or anything else like that that they can go to?
There is. So like you said, I do talk fairly regularly for different organizations. Um, and usually that'll be on our website under the events section of our website, upcoming webinars. Obviously, everything these days is a webinar. So some of the webinars that I did recently is last week I spoke on, I'm a council member of the Maryland State Bar Association's Consumer Bankruptcy section.
Okay.
We had the MSBA had a Legal Excellence Week with various different seminars, and the topic that I spoke on was a very novel topic of what we call force majeure and business interruption claims in bankruptcy, and how these insurance claims, essentially for businesses, they have insurance so that if the business stops, the insurance company should pay them something. That's actually an asset of the bankruptcy estate. So how does that come into play? What are some of the issues that are happening around the country? I also give webinars on the basics of consumer bankruptcy, business bankruptcy, and things like that. The new subchapter 5, which is streamlined chapter 11 to make it more less complicated and hopefully less costly, things like that. So the Maryland Society of Accounting Tax Professionals is another one, and I'm working on several in the next couple of months as well.
Great. What I guess tell us, what does your ideal client look like?
Honestly, that's an excellent question, and the answer I think changes over time. Mm-hmm. But the ideal client is one who is willing to receive help. It's really as simple as that. I think the one who understands that we ask for a lot of documentation. Unfortunately, we need that documentation to advise our clients. And I'll tell you, most of our clients are great about it. We request a lot of documentation and we get it. And there's some often back and forth to make sure we have everything. And there's more questions once we review everything. That process is, I'll tell you, in my experience, the hardest process, because many of my clients, they know they have a life insurance policy, but they don't have the policy, or they know they have a retirement account, but they don't have the statement, or I've seen clients with 5 or 6 bank accounts. We need all those bank statements. So it's a very difficult process, which I fully understand, but the ones that are willing and able, and they realize this is the best thing for me, they're committed to the process, and those make the best clients.
So us going through COVID right now and things like that, have you seen an uptick in people going the route of bankruptcy, or is it still too early to see that yet?
So I think we've been very, very fortunate in that our bankruptcy practice has remained steady since March. But the surprising thing is that if you look at the statistics of bankruptcy filings from March till now, and you compare it to last year's filings, there's a dramatic decline. So I think you'll hear, Pier 1, even Marcus, all these big companies are filing for bankruptcy. So I think there's a false impression that there's a lot of bankruptcies going on. Right. But when we get down to the mom and pop shops and just the families and individuals, those filings are dramatically down, and that's shocking. And what's going to happen, all the experts are calling for a tsunami. We're sort of heading towards this cliff where the paycheck protection programs, the government stimulus is holding up. But when that, falls off, I mean, it's just going to be, going to hit us like a wave.
Yeah. So lots of times, there does seem to be the negative connotation to somebody claiming bankruptcy. Um, how long, if you claim bankruptcy and you go through with it, how long will that affect you for from a financial credit standpoint?
So a bankruptcy, the way the credit bureaus report it is 7 to 10 years after the bankruptcy discharge, the court order that eliminates debt. So in I believe a chapter, it depends on the credit bureau, each are a little different.
Right.
But a chapter 7 is for 10 years after the discharge. Chapter 13 is 7 years typically after the discharge. So you're looking at when a lender, a car lender or a mortgage lender sees a bankruptcy, that's an extra risk. So because of that, the risk often results in a higher interest rate and more less favorable terms. However, there are steps that our clients can take after bankruptcy to rebuild their credit over time, and we partner with a program that actually is a step-by-step guide on how to rebuild credit after bankruptcy. Get certain kinds of cards, get certain kinds of loans, use them a little bit, pay them off every month, and really after they're able to rebuild their credit, that can dramatically impact their interest rates. So while bankruptcy certainly it does affect the ability to get credit, it's not like it's the end of the road. It's not like there aren't things that our clients can do afterwards to get back on the road to financial success so that they can be on favorable terms with their lenders and have a good credit score in the future.
So again, that's another good reason why to use a professional like you, because you're not only helping them get through the bankruptcy and get things discharged and kind of get them back on their feet, getting them back to their wealth. You're also going to help them be able to rebuild, their credit and their financial, their financial well-being.
Absolutely, absolutely.
So if the audience wants to learn more about you and connect with you, how do they go about doing that?
So the first thing I would suggest doing is just Google Steiner Law Group. You can read some of our client reviews. You'll be directed to our website, steinerlawgroup.com, and you can read some of our articles on the benefits that bankruptcy can provide. You can give us a call, schedule a consultation at 410-670-7060, or you can follow us on Twitter at Law Steiner, Facebook, Steiner Law Group LLC, and subscribe to our newsletter on our website as well, so you can get tips on how to set yourself up for financial success.
Okay. Eric, I really appreciate your time with us, and you provided us with a lot of great information, and I think that the listeners have definitely learned a lot today.
Thanks, Gary. It's a pleasure to be here.
So today our guest was Eric Steiner with Steiner Law Group, and we appreciate your time.
Thank you.
This show has been produced by Market Domination, LLC. To discover how you can have your own show completely done for you and turn it into a real published book and become the authority in your marketplace, go to www.marketdominationllc.com/podcast offer.